Oh wow, do you dig the shirt? Check it out. I actually picked this up at a gun show earlier this year. It was the most tasteful item I could find. I was wondering, maybe Wayne LaPierre could personally autograph it for me at some point in the upcoming future. Yeah. Well, anyway, I've been wanting to do a video, really a video series, more like it, about the state of gun control and gun culture in the United States of America, really since the Aurora shooting. So I've been waiting more or less a year to do this entire little trilogy of vlogs. Why did I wait so long? Well, I decided that if we're going to have a discussion about gun control and gun culture and just firearms in general in U.S. society, it needs to be something that's a little bit well thought out. You got to do research, you got to look at things from a lot of different angles. You have to be thorough, and you have to be kind of unbiased, but most of all, you have to be reasonable. And let's face it, the gun control debate in the United States is the least reasonable thing in the world. Ever since the Sandy Hook shooting, really the only difference that's made on U.S. culture as a whole is that it ended up making the gun control debate more contentious than any other issue in the U.S., including abortion. Therefore, we need to go back and actually talk about gun control and some of the things that are resting behind it. A lot of these deep-seated issues which affect everyone. And I decided to take a look at 3 topics for this trilogy of videos. And basically what I'm doing is I'm looking at the 3 most commonly cited reasons for gun ownership in the United States. This first video here is about, of course, the Second Amendment and how people supposedly have a constitutional right to own firearms. The second video is going to be about the whole governmental oppression theory that if you don't have an armed citizenry, you will be the subjects of tyrannical overseers. And the third is basically about how we have a God-given fundamental natural right to self-defense, which means even if we didn't have the Constitution, that we could have guns just because of natural law. That's a fun one. Can't wait to get to that one. But anyway, let's start off with the first one, which is about the constitutional safeguards that allow us to own guns, which really isn't 100% accurate. More on that later. So first off, when you talk to a gun person and you ask them, why do you own so many guns? Why are you into guns? Why do you think they're so cool? Why are you fighting tooth and nail to fight off against any sort of gun control legislation whatsoever? The most typical response you'll hear is, well, it's because the right to gun ownership is endowed to us as an inalienable right by the Second and Ninth Amendments, and they'll probably select 5 or more amendments just to kind of make it sound official. So anyway, their idea that the Second Amendment is the utmost qualifier of their rights to own firearms is really only true if you consider the United States Constitution as currently written, which hasn't changed since the late 1700s, to be the sole source of legal rights in the country, and that all other federal, state, or local laws are void. So basically, the Second Amendment is not the document that gives the United States citizens their consensus right to own guns in certain conditions, in certain qualities, at certain times. That's actually due to another, actually far, far more recent act of government, and that is the 2010 court case McDonald versus Chicago, where the United States Supreme Court, by a 5-4 decision, said that you do have the legal right to own handguns in your own home for self-protection. But that's as far as the law goes, and there are plenty of caveats, and we'll get to that later. So basically that, and not the Second Amendment itself, is what gives you the right to own guns based on a legal basis in the United States right now at this moment. So going back to the Constitution, if you do have this completely inalienable right to own guns due to the Second Amendment, that means that you have to look at the document as completely flawless, and that only the Supreme Court itself can be interpreters of that law, and other things like congressional executive acts and other state and local decisions are completely irrelevant. And then, of course, plenty of these things have been made without executive oversight. Things like Executive Directive 51, the McCarran Act, COINTELPRO, all of these things are completely anti-constitutional, but what do you know? They happen anyway. Nobody said anything. So once again, it's not like constitutional protections are completely enforced. In fact, they are pretty much liberally interpreted, depending on the circumstance, by acts of governmental officials have proven to us over and over again. So anyway, for you to say the Second Amendment and the Second Amendment alone gives people the right to own guns, or the Second Amendment in conjunction with the Ninth Amendment, or the 14th Amendment, or whatever, constitutional number that you want to choose in this roulette game, to say that that's the reason and reason enough that we should own firearms, or you have the legal right and no one can take that away from you, to do that you have to be an absolute constitutionalist. And if that's true, you got to look at the other parts of the Constitution. Why is it that you believe that the Second Amendment is the only amendment out of the entire first 10 Bill of Rights documents that has absolutely no oversight whatsoever? I mean, look at the First Amendment. The most important, perhaps that's why it was listed first as a startup for the fledgling country. The fact of the matter is there are tons of First Amendment restrictions going on. I mean, look at it. You've got obscenity laws, you have libel laws, you have copyright laws, you have incitement laws, you have a federal organization called the FCC, which mandates what you can and cannot say over airwaves. Clearly, that is an encroachment upon First Amendment expression by the government. But isn't that against the Constitution, right? That's completely against what the First Amendment says, but we allow it to happen anyway. That's because we don't view the First Amendment as an absolute document. We don't see it as completely and utterly 100% verified with no exclusions. The fact of the matter is, if you're an absolute constitutionalist, then you have to believe that child pornography should be legal. That having government officials go after that is squelching someone's First Amendment rights to expression. So there you can see this argument is really more about absolutism. If you honestly think that the Constitution is an unerring document and that alone, for whatever reason, gives you the right to own firearms, then you've got to accept a lot of other things that perhaps you would not want to. And if you don't, you, sir, are a hypocrite. And besides, let's talk about the Constitution itself. This is kind of an old argument, but you got to look at the historical context and say that it does not matter. The fact of the matter is, the Constitution was written at a time when the nation was newly formed, we're in the middle of active wartime, and technology, social infrastructure was totally unlike what we have in modern America today. Think about it. In the late 1700s, what did you have? As far as armaments went, you had muskets, you had cannons, you had sabers. The definition of what an arm today is completely different. It's not just a musket or a saber, it's an Uzi, it's a rocket launcher, it's weapons-grade plutonium. The fact of the matter is, times change, and with it, perhaps interpretations of ancient laws should change as well. So what about this? Think about the press. Before all this telecommunications happened, First Amendment was before radio, it was before film, it was really before photography, it was certainly before the internet, and all of this changed the definition of what speech in the press was. Therefore, the document was not seen as an absolute thing that could govern all of modernity because it simply could not have the ability to address modernity. And I think the same way you look at the Constitution as being flexible to be reshifted towards modern First Amendment changes, perhaps you should use it to reflect Second Amendment changes with our more high powerful weaponry. Let's face it, guns today are not the guns of this Revolutionary War. They're more powerful, they're more lethal, they're literally designed to be deadlier. If you don't take that in consideration, you're just being ignorant. And of course, there's that whole thing about the Bill of Rights really being an archaic document in itself that's hardly applicable to our modern society and infrastructure. If you're an absolute constitutionalist, basically what you're saying is the ideas of a bunch of bourgeoisie radicals from 300 years ago ought to be the only prescriptive legal force in the nation. So basically what I want to ask you that, if you believe the Constitution to be the only really important source of law we have as a people's that guarantees you your rights, or the rights you think are important, does that mean that additional scientific and medicinal and mathematical and technological models from 300 years ago should be our only resources and guidelines for modern development right now in 2013? I think that's pretty much an ill-informed decision. And of course, you got to have to remember the guys who wrote the Constitution themselves were kind of hypocritical. They went on about liberty as a God-given right of man, but they all owned slaves. I'm sorry, but it's kind of hard to take these guys seriously when they do stuff like that. So anyway, the Second Amendment doesn't really guarantee you much of anything because it's a flexible document, and we've already seen other acts of government interpretation which have shown that it's not the be-all, end-all as far as U.S. law. Now, the piece of American legal infrastructure that does give you the right to own guns to a certain capacity is actually a Supreme Court case from 2010 called McDonald versus Chicago, and by a 5-4 decision, the Supreme Court said that yes, you do have the rights as an American citizen to own handguns in your home for self-protection. But that's it, and as I said earlier, there are a lot of caveats to that. So I'm going to read you the majority opinion written by Judge Samuel Alito in that 2010 document. In it, he said, under our precedents, if a Bill of Rights guarantee is fundamental from an American perspective, then unless stare decisis counsels otherwise, that guarantee is fully binding on the states and thus limits, but by no means eliminates, their ability to devise solutions to social problems that suit local needs and values. So as you can see, even in the majority opinion of the document, which gives you a certain ability to own firearms, there is clearly a language in there that says, hey, it's not a complete and utter across-the-board universal right. The state, if there is a public concern, does have the ability and the legal ramifications to actually limit gun ownership to a certain capacity. And like I said, that's in the utmost law in the nation, giving you a right to own guns, stating that, hey, it's not absolute at all. So anyway, going back to the document in Heller, and Heller is the Supreme Court case from 2008, which laid out a federal standard for what was applied to all the states in McDonald, Chicago. So in Heller, we held that the Second Amendment, and once again this is Samuel Alito being quoted, in Heller we held that the Second Amendment protects the right to possess a handgun in the home for the purpose of self-defense, a provision of the Bill of Rights that protests a right that is fundamental from an American perspective and applies equally to the federal government and the states. So once again this is saying, hey, it applies to everybody. We're using the 14th Amendment. But of course, the 14th Amendment, as we all know, it only applies to state actors. So it doesn't apply to citizenry. So if you own a business and some guy comes in there with a gun and says, I have a right under the Second Amendment, actually, no, they don't, because the Second Amendment only prevents the government or government agencies from prohibiting your right to own guns or other firearms. So there, keep that in mind. This is not a universal right to own guns. And once again, this only touches upon home ownership in private homes, not businesses, and definitely not in a public sphere, so keep that in mind. So of course, the 14th Amendment, as we all know, is the Due Process Clause, and according to McDonald Chicago, the Due Process Clause incorporates the Second Amendment in McDonald Chicago. So even though we've had the Second Amendment around for the 1700s, it actually wasn't actually recognized as a legally binding thing up until 3 years ago. So a little tidbit you might want to know. So anyway, this all comes down to the question of semantics. Now we're talking about things like liberty, because you're allowed to own guns because it protects one's right to liberty. So anyway, let's look at the old standard. Nor shall any state deprive any person of life, liberty, or property without due process of law. And that's going back to the 14th Amendment. The thing is, we don't know what liberty is. There's no official government language that explains what liberty is, so that we have a right to be all liberty with things like guns and the First Amendment and whatever else we want to do. The closest I could find was a 1954 case called Bowling versus Sharp, and in that one Earl Warren said that liberty can be defined somewhat as the full range of conduct which the individual is free to pursue, and it cannot be restricted except for proper governmental objective. So as you can see, it's very vague, but even in that incredibly vague, loose interpretation of what liberty is, it says pretty much cut and dry that, hey, it's not absolute. The government has the ability to restrict it for certain and peculiar reasons. So anyway, basically what McDonald versus Chicago says, and this is the most important case if you're a pro-gun guy, is that you do have the right to bear arms as long as it is fundamental to our American citizenry scheme of ordered liberty and deeply rooted in the nation's history and tradition, which to me sounds like a really stupid and subjective way of interpreting law, but whatever. So anyway, part of that is that self-defense is a basic right and firearms can be used for the protection of one's home and family. And actually that kind of goes back to an earlier passage, which is the Civil Rights Act of 1866, which once again was not really a constitutional act, but rather a congressional lawmaking activity. So there, if you look at it, the foremost legal document in the United States that gives you a certain ability to own firearms actually stems not from the Constitution, but actually an interpretation of the Constitution by the Supreme Court based on a congressional act from 170 years ago. So there you go. That's a little funny to think about. And of course, really can't talk about gun control or gun ownership law in the U.S. without talking about the District of Columbia versus Heller decision in 2008, which 5-4 decision, a government decided that you kind of had a basic right to own certain firearms in your home, but that's it, and all the other gun laws are not vacated. So stuff like the Brady Act and the Weapons Control Act of 1934 are still going on. Actually, it's not the gun control of Nazi, that's actually the Nazi Germany policy, but we'll get to that in the second video. So anyway, in Columbia versus Heller, this is a quote from the majority opinion. Like most rights secured by the Second Amendment, it is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. It does not have the effect of prohibitions on commercial gun sale regulations, guns in schools or government buildings, and no sales to felon. So basically what it did was it upholds the National Firearm Act, which was basically given the thumbs up in the United States versus Miller from 1939. And under DC versus Heller, Miller said, as we have explained, that the sorts of weapons protected were those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. So once again, look at that. This is the document which is probably the second highest ranking in the U.S. history, which gives you the right to own guns. And look at what it says. I'm going to read that again. Miller said, as we have explained, that the sorts of weapons practiced were those in common use at the time. We think that limitation is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. So even within the framework which gives you the right to own handguns in your home, there is a clear-cut governmental statement saying that, hey, you don't have that absolute freedom and it can be curtailed. And we do have all these previous laws which we still believe are valid and are going to be upheld that are not changed by this decision. So basically what you really got from Chicago versus McDonald was not much, because it didn't agree to say, hey, you have the right to own Uzis or automatic weapons or carry them in public spheres or take them to government buildings or own hollow point bullets or how to sell them or traffic them or anything else. It just said basically you have a fundamental right to a certain capacity to own small arms for protection of your own home. And not your business, just your home. But like I said, that might get changed in the upcoming years. So anyway, all that to say, basically, Second Amendment matter in determining whether or not you have the right to own firearms. Not really. There's plenty of other laws on the books, including the highest ranking one, which is actually a Supreme Court case from 2010, which says that you do have a certain ability to own firearms, but it's not across the board and it's not completely unquestionable. And before I conclude and move on to the next video, I'll tell you about something called U.S. Code Title 18, Part 1, Chapter 44, Section 922, which is about limiting who can have guns or other firearms in the U.S. And this is something that's been upheld in both DC versus Heller and Chicago versus McDonald. Under the code, you cannot own a firearm in the United States if you are a felon, which means you've spent more than a year in jail, you were accused of domestic violence, you've had a restraining order placed on you, or you use any kind of drug, marijuana, cocaine, across the board. If you do drugs, technically you're not allowed to own a gun. Of course, it is a very much unenforced policy, but considering that we're dealing with all these gun control legislations, perhaps that's not a bad idea. That when you go in, instead of having a background check, you just sit there, you take a urine test, you give it to the guys, and if you pass, you get your handgun, and if not, I'm just upholding the law.